Okay, so it is 4 o'clock and I will go ahead and call the meeting to order. I first have a motion for the approval of the agenda, moved by Bill and seconded by Tom Dewey. For the agenda of the regular council meeting for May 18th, 2022 be approved as presented. Are there any amendments?
None.
None? Okay, seeing none, all those in favor? Okay, motion is carried. Are there any disclosures of pecuniary interest or any general nature thereof? Okay, seeing none, it will be noted in the minutes. I also,
That's it.
that's it. Okay, so this is perfect.
Then you can turn it over to.
Okay, so we're ready to welcome Glenn Tunnock here for his presentation to us. Welcome, Glenn.
Thank you very much, Madam Mayor, members of council, and the gallery behind me. It's great to be back. I guess retirement is a relative term. I could be sitting on the lake in my pontoon boat or driving a 49 Ford at one moment, and then next moment I'm preparing a minor variance report or something for some municipality in Northern Ontario or wherever. But it's been great. It's always been a particular pleasure in working with Central Frontenac. There was all that spontaneity, that social discourse, which was always a lot of fun and a lot of enjoyment for me. And I do feel I've left, I think, a bit of a legacy in the sense you have a couple of strong documents that were prepared some time ago that have been modified, but I think they've stood you fairly well. I think your zoning bylaws been in place now for over a decade, and it seems to be holding up from what I can see. But here we are 10 years later from the time it was prepared. You've got a new official plan or an updated official plan, if you wish. You've got changing circumstances. You've got people that now prefer to live and work at home as opposed to driving to the office in Kingston or Ottawa for that particular matter. You've had COVID. That's certainly had an impact. You've got increases in real estate values, and that's had an impact. And certainly you've had a fair amount of development over the past while from what I can see, and that's certainly had an impact. Climate change is another impact that we're gradually facing more and more of an impact on, and we have to certainly look at that from a serious standpoint. And the Planning Act has been changed. It's been a challenge for even me to keep up with the amendments to the Act, even as recent as just a few days before Premier Ford called the election. So that has had an impact on municipalities, not just yours. So in undertaking a review, one has to take into consideration changes to the Act that legislate changes locally. You have to take into consideration changing circumstances locally. And I'm going to say right at the outset here is that your local knowledge is just as important as my planning advice, because you know your community better than I do. I had the privilege of working with this community for a number of years, but things have changed, and not living here certainly has its disadvantages in understanding kind of the day-to-day circumstances in your community. So I'm going to be depending on you for your local knowledge to help with this particular review. I also want to point out that no question is a silly question or a dumb question, okay? The zoning bylaw is a very complex document. It's probably one of the most complex documents you will deal with as a municipality. And one doesn't expect every councillor to have intimate knowledge of zoning and how it applies and the history and all that sort of stuff. So there's kind of a two-way street. You with your interests, your local interests in mind, me trying to make sure that whatever you adopt is going to comply with the Planning Act, with your official plan, with the provincial policy statement. So it's definitely a two-way street. It's not me having all the answers, because I don't have all the answers. And what we look at to some extent are our best practices is what's going on elsewhere in Ontario. And Councillor Dewey, he sent me a copy of a fortification bylaw from Hamilton. Well, Hamilton does it in a certain way. Other municipalities do it in a certain way as well. And I think it's important to certainly modernize the bylaw. You've had things happen like cannabis legislation has come in, so that's something that might be incorporated into the bylaw. You've got live work units, which is a new concept that the county official plan contains, and your official plan contains as well policies on to deal with. And I also want to point out is, notwithstanding there may be legislative changes you have to deal with, you have what I would call community standards. Okay, there's stuff the Planning Act doesn't really deal with, or even the official plan for that matter. And so it rolls back to you as a council to make decisions on, such as storage containers. Okay, storage containers has been an evolving use right across the province. So it raises questions: should they be regulated? If so, how so, why? And recreational vehicles is another thing that they've been around for quite some time, but they're not regulated by the province. It's kind of left to you as a local municipality. So as we go through some of these materials today, it'll be your decisions that count on where you think the decision is in the best interest of your community, that it meets your community standard, and your community standard may be different from South Frontenac, North Frontenac. It's what's important to your community. I've had the opportunity to review the email streams that have been generated by Cindy's work. And I want to say a real heartfelt thanks to Cindy and to Kathy for their support and the information they sent me. So it is truly a team effort in that respect. But I've reviewed the materials that have come through, and it's inevitable that you're going to get certain polarization from one end of the spectrum to the other. So some people say, yes, we need zoning, it's important because it controls development. And other people saying, no, I want to be able to do what I want with my property. And but the thing is those are the people that will probably come forth and be the first to say, well, I don't like what's going on the next property over. Why didn't you regulate it, you see? So there are various opinions, and they can be polarized. But and in any case, I've had the opportunity to look at all of the email stream that has been generated by this consultation process, and certainly consultation is an important part of where we're going. That is in fact legislated by the Planning Act, so we have to consult with the public, and we'll talk later this afternoon on how we do that, when we do it, that sort of thing. One of the points I do want to raise as well is related to the living environment here in Central Frontenac. You have lakes that are gems, People come here because of the aesthetic value, because of the environmental value of your lakes, your rivers, and in general, the rural setting that you have. That is precious. That is precious. There's lots of urban municipalities that would love to have those kinds of attributes. And so one of the responsibilities this council has, and to date it's exercised that responsibility fairly well, but one of the exercises and responsibilities you have is to sustain that natural environment for your generation and for future generations. Keep it healthy. Keep it healthy. And I suggest to you that when you make a decision on a zoning amendment, think in terms of whether there's going to be a net benefit to the environment by virtue of the development occurs. I would suggest to you that it is more important to mold development into the natural environment rather than mold the natural environment into development. In other words, environment comes first. environment comes first. And if we don't protect our environment, we will suffer the consequences. You'll see deterioration in wildlife habitat, fish habitat. You'll see actually a decline in property values. One of the things that's always stuck with me over my career is the fact that properties that are well landscaped, well maintained, natural vegetation have a higher real estate value than a property that's clear cut, you see. So please always remember the environment when you're making a decision as a council. Your zoning bylaw does contain a lot of very strong standards that are designed to protect the environment. And it's left to you as a council to ensure that sustainability, that long-term environmental sustainability is maintained. And of course, a lot of the pressure today, as you know, is on the waterfront. And you're no different in that respect from many other municipalities with a lot of lakes and river systems. I live on Audie Lake, and it's the same on Audie Lake as it is on Charbet Lake and Long Lake and a number of other lakes in your municipality. A lot of the prime real estate has been bought up and developed. And what you're seeing is redevelopment of existing lots. So people are buying cottages, converting them to sometimes tearing them down and building permanent homes, or they're converting cottages to permanent homes, or they're expanding existing dwellings, you see. So there's a lot of pressure for development, and that will continue because land is not infinite in supply. You know, there are constraints in the amount of land that you have for development, and you have to keep that in mind as well. So those are just, I guess, some of the background, I guess, if you wish, in terms of the approach, the methodology I've used, I've set out in my planning report of April the 27th. I've reviewed the county plan. I reviewed your township official plan, the latest version. We've had a meeting with the county just to talk about zoning issues in general. We've had a staff meeting with township staff. I've done some online research, and there's also been some consultation that has occurred already with the people on Kennebec Lake as an example on the issue of short-term rentals. And so there has been a fair amount of effort that's been put into it. I have prepared a draft bylaw, which you have seen, draft amendment, if you wish, that's been incorporated into the bylaw. And I consulted with Tony Fleming as to whether we could red script the changes and have strikeouts and that sort of thing, and use that as a way of amending your bylaw, as opposed to preparing probably a 50 or 60 page separate document. So you have a document that's got a lot of verbiage in it, and you're trying to understand that with the zoning bylaw. So I think it's a lot easier when you have a document that you can read through and you can see the changes right in the document. You say, yeah, there's that red line change. I understand that, as opposed to trying to read a second document. So I'm pretty pleased that Tony Fleming has said that that's the way we can go. We can say, hey, the red script is a legitimate change. You don't have to have a separate bylaw to do it. So that's good. And I hope you've had the opportunity to read through the draft. And I would say that that draft is the first draft. It's a draft where I've made most of the changes, but I have not incorporated, or had not incorporated, all of the amendments that Cindy gave to me. I have prepared a subsequent draft that contains all of the amendments since basically, I guess, 2011. So that draft will be made available to you, but we didn't want to confuse matters right now, giving you a second draft yesterday, and you're trying to deal with the draft in front of you. And again, I'm certainly amenable to any comments, changes, proposals that you might have. Are there any questions to date then on what I've said? Doesn't make sense to you? Okay. Then let's deal with, I guess, some of the issues. So you have my planning report in front of you from the 27th, okay? And the first issue is the affordable housing issue. And that is kind of a legislated issue in part. The province said to municipalities about 4 years ago that you must amend your official plans and put the provisions in your zoning bylaw to provide for what's called additional residential units. They used to be called second residential units because there was one change to the act that provided for a mandated second unit in a dwelling. And then the Ford government changed the act again. So now you're allowed basically 3 units. That is to say, if you have a single detached dwelling on your property, you can have an apartment in the house if you wish, and you can have a separate detached ancillary unit on the property, usually in the rear yard. So additional residential units were deemed to be a way of providing additional shelter or housing for municipalities, for people across the province at something that was more affordable than having to buy just a single unit. The official plan. Yeah, I'm on page, the bottom of page 2 of my planning report. Yeah. I can get into the actual details in a minute, but I just wanted to give you a bit of background on the additional residential units. So the official plan that you have relates to the earlier version of the act. But in my opinion, you can better comply with the Planning Act by allowing that third unit where it's appropriate. What I've done as a proposal in the update here is to say additional residential units are appropriate with certain caveats. Okay. You know that virtually all of the development in this municipality is based on private services, wells and septic tanks, okay? If you don't have a lot that's large enough to sustain that additional 1 or 2 units, then that's going to cause an environmental issue. And it's particularly significant when you're talking about your lakes. You know there's a biological development capacity on your lakes, so you don't want to overload the lakes simply because you want to provide additional units. So what the proposal is in the update is to say in the waterfront residential zone, okay, you won't be allowed additional units. Does not prevent somebody from coming forward for a minor variance where they can prove that, say they have a 4-acre lot or a 5-acre lot, and so it's large enough to put a second unit. It's not to prevent somebody from doing that, but without doing a comprehensive assessment on your water quality, it would be unprofessional for me to say, go ahead and allow the second unit and the third unit on waterfront properties, because you don't know what the consequences might be. And I'm also saying that even in other zones where we're suggesting the additional residential units be allowed, that you do it on the basis that you do have the sewage capacity without it being a negative environmental impact on the lot or an adjacent lot. Glenn's fine.
Okay, thank you, Glenn. Through you, Madam Chair. This actually triggers a question that I was going to ask later on anyway. You mentioned the possibility of applying for a minor variance.
Yeah.
What is the difference between a minor variance and a zoning bylaw amendment? What sort of triggers that? A minor variance is not a serious kind of affair. You just come before the Committee of Adjustment and they assess it and will grant it or deny it.
Yeah.
But a zoning amendment bylaw or a zoning bylaw amendment is a much more complicated and thorough process. Where is the line?
There is no defined line, and that makes it somewhat difficult. But some municipalities will use a rule of thumb that if the variance is greater than 10% of whatever the standard is, then maybe you should go to zoning amendment. The benefit of a zoning amendment is that you incorporate it into your zoning bylaw. And it's easier for a subsequent party or somebody that's researching your municipality just to find that change right within the bylaw, as opposed to minor variances, which may be recorded against the property. They're in the municipal files, but they're not as easily accessible. What I look at though is really what's the impact? If you had a situation, well, let's take the situation we're talking about. So we've got somebody that has a minor variance request for an additional unit. And we'll say that the lot is a half acre as opposed to 2 acres. And it has a sewage system that might be 20 years old, 25 years old. I would question right off the bat whether you would have whether the variance would be minor in that situation, because the impact would be fairly significant. It would have a significant environmental impact on that particular, not just on that lot, but perhaps the adjacent lot, because you wouldn't have the room to expand the sewage system. Okay. And you may not have the distance separation between the well on an adjacent property or even the well on your own property. So, and a minor variance to increase, say, instead of 1 unit, the person says, well, if I can get 1 unit, why not get 3 or 4 or something of that sort, you see. So it's really boils down to what your perceived impact is going to be in making the decision. If you think the impact is going to have a significant impact on the environment, it's going to have a significant change on the character of your residential area. For instance, so you have an exclusive single detached neighborhood, single detached residential neighborhood, and somebody comes in and says, I want a minor variance to put in a 3-story apartment building. Well, that's not a minor variance. That's got to be a major impact. So that would be a zoning change. A lot of from what I can see, and correct me if I'm wrong, Kathy, what I see is you have preferred to use the zoning route for most development. Is that a fair statement?
Yes, and I think that there's some cases with the minor variance, I know Cindy's been attending, and of course, Crystal's here as well. So as to what the applications are coming forth for variances. And I mean, the committee is all of council as well. But majority of some of those things be more zoning bylaw amendment. That's what I would take as well, because of the impact. So, okay, is there any?
Well, sort of a follow-up here. Yeah, so there's no clear legal definition, because
Don't tie yourself down to a legal definition. Because,
I want to know if there is one.
Yeah, there isn't.
Because some of my questions about permitted uses, right? Do permitted uses fall under zoning bylaw amendments rather than minor variances? Like the minor variances that we are usually faced with are things like shoreline setbacks.
Okay, if there's a change of use, in my opinion, that's a zoning amendment. You don't change the use on a property from residential to commercial, okay, through a minor variance process. That's not appropriate.
Okay, so then the example that has been brought up would be like the second unit on a waterfront. Would that fall under zoning, or would that fall under minor variance?
Again, I would suggest that it might depend on the individual circumstance. If it's what I call a postage size lot, I would question whether minor variance is appropriate. You see, I kind of prefer the the rezoning as the way to go. If it's a fairly large lot, and you have, an adequate space for sewage and for the additional unit, I think a minor variance would probably be okay.
How is the decision made about which process will be used?
Well, that's in part why you have a professional planning advisory service from the county, and I think they're the ones that can when they see one thing that Central Frontenac has done, which is beneficial, is they have mandated pre-consultation, and it's the pre-consultation process that allows the county planner or municipal staff to say, have you thought about this, or what's your proposal? Okay, so you sit down with the individual and talk to them about their proposal. And then on the basis of that pre-consultation, you can say the minor variance process is the better for this particular application, or zoning is better, as the case may be. And the mandated pre-consultation is something that kind of kicked in about, I don't know, 7 or 8 years ago or something of that sort, some time ago. And the pre-consultation is designed to make it easier for the applicant to know what is expected of him or her or them to proceed.
Okay, thank you. That does answer my question.
Okay.
Thanks.
Through you, Madam Chair. Glenn, in your provision of additional residential units, you're saying here that units cannot happen in waterfront properties. And you have to have, it requires an impact on water quality, requires adequate sewage disposal. Would that not be appropriate also in any kind of environment? Whereas if you're adding a granny flat or whatever you want to call it, or additional converting your garage to living quarters, wouldn't it be absolutely necessary to know what impact that was going to have on water source and or sewage disposal at the same time, rather than just saying waterfront? Wouldn't that apply across the whole township?
The proposal is it does. It is, so even in the zones where it would be permitted, you'd still have to justify that you had the proper sewage system or proper sewage capacity for the system. Okay. One small item that, and this may have come up, I'm not sure, is the conversion of a storage container to an additional residential unit. Your bylaw now makes provision for that sort of thing to happen. We recognize that storage containers have been used quite effectively in many parts of North America to provide for additional residential units. And there was a comment that was made, or question that was made, about the building code and the flexibility to allow for different types of housing styles. And the Building Code Act, in fact, allows your building official to evaluate whether a straw bale structure or something made out of some other types of materials would qualify for a residence, for building a residence and so forth. And a container, storage container, would be the same sort of thing, but obviously they would have to have the building plans to justify that that would be appropriate. But so in addition, so a storage container could theoretically be that accessory residential unit on a property. The other element to, sorry.
Glenn, just when you just reminded me of something when you're talking about those sea cans, and I know there are some people that live in them. There's also a person I know lives in one that's on wheels. It's actually a 40-foot trailer. And we haven't included that in here. Is that something we should kind of put in there? And is 40-foot trailers allowed on a lot? I just thought about it because I know there's one in Stone Mills. I drive by it quite often. A 40-foot trailer, and they converted this thing over into a livable space. And it's still on wheels.
Okay, so in that situation, the building official has to be satisfied that it would meet the requirements of the building code. And there's a couple of ways I think to deal with it. You could deal with it somewhat like you deal with a mobile home, is that the expectation is that the wheel assembly would be removed and the storage container, or sorry, the mobile home would be placed on a proper foundation. And I guess the expectation would be that if you had a storage container on wheels, the same principle should apply, that it should have a proper foundation under it.
I don't know what the person has, but it's something that happened. I don't know what they're doing about. Probably a zoning issue, but, and I suspect she has no house. And I also suspect she probably has some kind of.
Use your mic.
Okay, I'm sorry. Oh, here we go. Sorry about that. I pressed the wrong knob here. Sorry, but I'm wondering, I suspect she has some sort of gray water disposal, because she obviously has to wash stuff inside. And I suspect she has an outlet. But the thing is that I was just thinking about that, because it is there. It's something that we probably should not allow to happen. And like I think you've answered that question, because you said if it doesn't conform to our zoning, because this thing doesn't have proper sewage and that sort of thing, I think that would probably cover it. So I'm probably saying something here that doesn't need to be addressed. I just thought about that, but it would be handled under our zoning, I suspect.
Yes, go ahead, Bill.
Yeah, so are we happy then with the proposals for additional residential units? You understand the.
Sorry, I think Councillor McDonald just had a question to follow up.
Through you, Madam Chair. Glenn, Councillor Dewey noted outhouse. In actual fact, that is a form of disposal that's acceptable, I believe, in our official plan. Am I correct in saying that?
The wording of the official plan of your zoning bylaw, because that's what count says, that the sewage treatment system must meet the requirements of the building code. Okay. And so it's up to whoever administers the building code to make that call, whether a privy is acceptable as opposed to a conventional sewage treatment, a class 4 sewage treatment system, which is the one that is usually installed when you're talking about new development. I think you'd want to discourage a privy as an option, but what the way your bylaw reads right now is that as long as you comply with the Ontario Building Code Section 8, then it would be acceptable. Yeah. Okay, so we're okay with the additional residential units? Okay, so the second component of the affordable housing is tiny homes. And tiny homes are the bylaw has a proposed definition, and it's something I've incorporated into a number of other zoning bylaws I've done across the province. There are two issues here, basically. One is, what's a reasonable size for a tiny home in your municipality? Okay. And I guess even before that, do you want to allow tiny homes in your municipality? The official plan does give kind of a background and encouraging different types of housing units. So tiny houses are potentially one of those types of units. And the province has recently amended the Building Code Act to provide for tiny homes in municipalities as well to ensure that they're properly constructed, they're safe, and obviously they would have to be properly serviced. So going back to your comment earlier, Councillor Dewey, about wheels, is that the expectation is that if you install a tiny home, it would be put on a foundation. It's not one of these that you can roll in one day and roll out another day. The intent is to install it as a permanent feature. Now, in the definition that I put in your bylaw as a proposal, I mean, it's up to you. It calls for a minimum floor area of roughly 300 square feet, which is greater than what the Building Code Act could potentially apply. Or applies. The Building Code Act would allow a tiny house as small as 17 square meters, as opposed to what I'm suggesting here of 27 square meters or 300 square feet. The argument being that it's still affordable, but it's a larger unit giving more space for not just say an individual or even a couple, potentially for a family as well. As you can see on the top of page 3 of the planning report, it's the building code does provide for a tiny house of 17.5 square meters, not 17, sorry, which is 188 square feet. So that's pretty tight. But I guess the other bylaws that I've written that have the 300 square feet is they seem to have worked, but it's a decision of your municipality as to whether you think you could live with the smaller amount, or you think that a larger floor area is appropriate. A tiny house in the literature is usually something between roughly a couple of hundred square feet to about 500 square feet. And when you reach the 500 square feet, the definition usually changes to small house as opposed to tiny house. So there's a bit of a distinction there. I guess my question to you is, has there been any request in this past while from anybody interested in building a tiny house in your municipality? And if so, is there some idea as to what the floor area might be in that circumstance?
I can ask Crystal, because I mean, she works with Andy, asked to see if there's been any requests for tiny homes. Has there, Crystal?
Yeah, there's been requests for tiny homes. Plus, like.
So that Madam Mayor and Councillor Cameron can hear as well.
So there has been requests for tiny homes. Also, a lot of people want to do the 108 square foot, so they think they can get out of a building permit, but you can't if you're going to occupy it. So yeah, we do have a lot of requests.
Inquiries.
Pretty much everybody that buys a lot nowadays wants to do that to start out with until they can afford to do a cottage house.
Hmm. So in other words, 300 square feet would probably would be beneficial then at that size.
Oh. You have a question, Fran?
Yes, I do. Just more comment. I live in a small house, not a tiny house, 730 square feet. And that's small, but I think if we want to have something that people could be comfortable in and not have to keep adding to it over the years, 300 as a minimum sounds pretty reasonable. And if it's a range of 300 to 500, I think that gives people an opportunity to actually be comfortable living in the tiny house. That would be my recommendation, is 300 to 500.
Go ahead.
To you, Madam Chair, to Glenn. Glenn, with this, adopting the tiny house policy, throughout the township, I'm sure we have a tremendous number of non-conforming lots that would not accommodate a normal residential home of any kind. Given that we're going to allow tiny homes, and I agree with it, would this perhaps solve an issue where we have a shortage of housing and also make use of some non-conforming lots that otherwise would never get used?
Well, Yes, I think the answer is yes. I mean, again, this zoning bylaw does allow development on undersized lots, meaning a lesser lot area than's prescribed in the particular zone and maybe lesser frontage. And again, as long as you can put a proper sewage treatment system on the lot to service the tiny home and have the distance separation from the sewage tile field and so forth, and what happens on an adjacent lot, then you should be good to go. And provided you can meet the setbacks as well, the required setbacks in that particular zone. There may be, going back to your question earlier, is that you may get a situation where maybe 80% of the zone requirements can be met, but maybe you're squeezing on one setback or something like that, then a minor variance might be appropriate. Maybe you can't meet the minimum setback in the front yard or something of that sort, so it might be appropriate. But I think your point is well taken, that it may be a good use of undersized lots and may make you, may help you answer that question of affordability or affordable housing for people in your community. So I'm getting a sense then from the mayor's comments and kind of the body language here that the 27.8 square meters or 300 square feet would be appropriate as a minimum.
Sorry, Victor, go ahead.
Yeah, through you, Madam Chair. It seems there on your side, there's a little hesitancy between the 188 square feet up to the 300 square feet. What is the drawback of allowing something less than 300 square feet? Now, Madam Mayor mentioned they start with 188 and then they build an addition and another addition. Are there any other drawbacks? So, I mean, I don't know where the line should be.
Yeah.
I'm just wondering, in your experience.
Yeah, I think the drawback, as I see it, is less versatility in the use of the building to accommodate, say, 2 or 3 or 4 people. You see, I think 300 is a squeeze for even 3 people or a family. But I think that would be the drawback, is that if you go with 17.5 square meters, I think you're pretty much looking at one person occupying that, and that would be the limit. I mean, a second might be very, very difficult. But so if you want to provide, I think, the versatility to answer shelter demands or shelter needs in your community, I think the slightly larger size would be appropriate.
But if you have a single person who has no intention of living with anyone else, now you are requiring that they build up to 300. That almost seems as if we are sort of demanding the social circumstances by setting a certain size.
Yes, and I might sound like I'm contradicting myself, but one of the reasons why I, a decade ago or more, suggested there not be any minimum floor area requirements in your zoning bylaw was for that very reason, is to enable people to build smaller houses that they could afford, as opposed to meeting a minimum standard that might be a social standard in the community. But again, it's what you think is appropriate for your community and what's acceptable to residents in general. I think you will get some feedback from people that may have bought a lot and have put a $500,000 house on the lot brand new, and then you've got a tiny house in the next lot, and they're saying, well, how's that going to affect my real estate values and so forth and so on. It's a difficult judgment call to make. But if you opt for the 300 square feet, again, you can use a minor variance process for somebody that says, look, council or committee of adjustment, I think, it's just me, and this is going to be my retirement home, and I don't need 300 square feet. So they could come in for a minor variance. So it's not something that's necessarily etched in stone, but it's trying to strike that balance between what's the character of your community and how a tiny house would fit into the existing character of your community. There is in the provincial policy statement and in your official plan, a policy that talks to built form. And that became a requirement about 6 or 7 years ago. And really it requires a municipality to assess what's an appropriate built form for, say, Charlotte Lake here, okay? So an inappropriate built form for Charlotte Lake would be a single detached dwelling on a predominant 2 to 3 story settlement pattern, and then suddenly somebody coming in for 12-story building or 15-story. Well, that's not what you consider part of the built form, the character of the built form, you see. So I think the same applies to a tiny house to some extent. Is you're looking at molding it into the existing character of your community and making it look like it's part of the community as opposed to some strange anomaly.
Thank you. Your answer satisfies my concerns.
Okay. So we're opting then to go with to allow tiny houses and we're talking about the R1 zone, the waterfront residential zone, the rural zone, and the LSR zones.
Glenn, I did, before you go off the tiny house bit, and it may be not an issue here, but I just thought of it. Is there any need to regulate the height of this house? I'm just thinking here, if somebody wants to put, you get a permit to put a small tiny house in 300 square feet, and then they suddenly decide in their mind when they're building it, oh, we'll stick a little loft up in there. Is that going to be included is that's going to increase the height of the house a little bit? Maybe they'll put a bedroom up there, a little sleeping area. Is that something that we should look at, or is that not?
That would be acceptable under the code.
That would be acceptable?
Yeah, as long as it can
Okay.
meet the building code, you'd be okay. I mean, there was some issue, I think before they modified the building code, there was, as I understand it, an issue as to whether a loft would be something that would meet the requirement of the code. But so there's been changes. So it's really to some extent the call of the building official, and a 2-story. If you call it a 2-story, it might be a story and a half, would certainly meet the height requirements of your bylaw. Okay, so we're good to go on tiny houses then? Okay. Okay. That in my notes. The next topic is recreational vehicles. And again, going back to my earlier comments, it's a community standard. What's appropriate for your community versus North Frontenac, South Frontenac, or Perth, or whatever. And the way your bylaw reads right now is that you only allow the storage of recreational vehicles on properties, with the exception of somebody that has a camp. So you've got a commercial camp, and you allow recreational vehicles in that commercial camp. So the issue here, and again, I'm leaning on you people for your local knowledge, and Crystal and Soph and Cindy as to what's actually where the pressures are. Are recreational vehicles a significant issue in Central Frontenac? Do you want the flexibility to allow people to use these as temporary accommodation in advance of building a house or something of that sort? Or do you want to say, no, we're just going to leave the bylaw the way it is, and you can't use a recreational vehicle in this community? So the options, as I've said, prohibiting RVs except in a commercial campsite, limiting RVs to being stored on a lot only, which is the case right now, or permitting RVs for temporary accommodation during construction, RVs for accommodating immigrant farmers that are providing a service to your community as well. So there are different options here. So I'm going to throw it to you to tell me what you think is, what's going on in central Frontenac, and is there a need to regulate recreational vehicles?
I can certainly speak, and I mean, Crystal and Cindy, yes, there certainly is, because I mean, people are using them on occasional uses, as we know, and not in the main house. It's either for certain, there's been certain issues that has come forth. So I think there is a need of that, how we want to deal with them. That's something we're going to have to certainly think about, but I think Crystal and Cindy are certainly well aware. They get lots of questions on people wanting to have them on a vacant lot as well, and certainly living in them. So there is that need out there. So, and I mean, the other thing too, as we were talking about, when you talk about RVs, and I think Glenn, I already mentioned to you once, because I certainly have heard that recently of folks that have large parcels of property, of having campsite, having their family, having a festival or whatever. And that could happen here, because I mean, it seems to be discussing now of some people with large parcels, gee, we could have a jamboree, or we could have this, and just for a weekend. So there's things like that, but then also what comes into part of that would be inspections, like fire, and we've got the fire chief with us, fire inspections. I know, for instance, and I mentioned that to Chris as well, we had attended a jamboree or whatever up in Pembroke, and I know it was under their bylaw. And as soon as you drove in with your RV, fire department was there, they were going in. You had to step out, they were checking for CO detectors, and they were checking for your fire, as well, your fire alarm, making sure that your smoke detectors and everything were working. So, I mean, there's lots of other issues as well. And of course, with propane, I mean, they can certainly, we've had that instance here with one in the village here, just a year ago, trying to get ready to go, and whatever happened, and it caught fire, and it, so in a small area, then that was just stored at that point. So, but there's things certainly to consider.
Okay, I want to diverge a bit at this particular point, because this is an extremely serious issue in this municipality as well as others, and it's the issue of enforcement. Okay, it's nice to have bylaws in place, but bylaws are only as good as the enforcement of those particular bylaws. And there's two particular issues here, and we've actually dealt with a couple that already, but there's two very serious issues. And I think it's the reason that Terry Kennedy is here is the whole issue of short-term rentals and the issue of recreational vehicles. They can't be regulated solely through zoning. Okay. And to do what Kathy is suggesting to do for recreational vehicles will require a trailer licensing bylaw. And there's another reason as well, is that when you install a trailer on a vacant lot, you're immediately going to be you're replacing a demand on municipal services, because you're using the road system in the municipality. You're depending on fire services, okay, because of, fire protection, and there may be other services as well. So there is a cost there which is not being recovered, because a recreational vehicle doesn't pay taxes. There may be taxes on the vacant lot itself, but there would not be municipal taxes on the occupancy by a recreational vehicle. So trailer licensing bylaws, and I've drafted these for other municipalities across the province, invariably contain a licensing fee intended to offset the operational cost of providing roads, providing fire services, those direct services, not the whole range of municipal services per se, but a prorated charge that is considered to be reasonable to offset the cost of, degrading the road in front of the property, dust control, that sort of thing during the summer months. So I do think this municipality has to look very, very seriously at enforcement, and whether you think you have the resources to take on some of these additional responsibilities to ensure public safety and financial sustainability of your municipality are addressed. So recreational vehicles, I think it's not an unusual or unreasonable issue to address in a zoning bylaw, but there is the corresponding concern about fire safety, about the cost to your municipality and getting the bylaw enforcement officer out there. And then, as Kathy alluded to, and we've dealt with this in other bylaws too, is having a little jamboree in your community. So you got a bunch of these that might show up on a weekend or something like that. A family reunion, quite common in French Canadian municipalities in this province, people coming together for a weekend or even a week for that matter, and having 5 or 6 RVs on the property. So I'm getting a sense that there is a need for the way the proposed change in your bylaw that I've built into the bylaw is written. It's designed to treat a recreational vehicle much the same as a conventional dwelling, even though it's considered non-residential, temporary accommodation, non-residential. It treats it the same way in the sense that you have to meet all the setbacks, lot area setbacks, height controls. It doesn't allow for a permanency in the sense that you can't build add-ons. Okay, so that the recreational vehicle is there as a unit, and you've seen I think in the draft bylaw, the examples, the photos that I've built into the bylaw. So the intent is that they only be temporary, pending perhaps the construction of a tiny house or a conventional house or something of that sort, you see. But as I say, a recreational vehicle in terms of what I've written as a proposed change would treat a recreational vehicle the same as a conventional dwelling. Have to have proper sewage, because the question is raised is, if you have a recreational vehicle on your property on a vacant lot, what do you do with the sewage? What do you do with the sewage? Where's the closest pump out station to dispose of your sewage, you see? And again, going back to my concern about the environment. So if you so that's the proposal here, and again, if it's on a lake, you have the proper setback from the lake as well, and treat, as I say, recreational vehicles as a conventional dwelling. So is that the way you want to go as a council?
Sorry, Glenn, I think Madam Mayor had maybe perhaps a question or comment, and then as well, Councillor McDonald.
Yes. My comment is that every household or every second household has an RV sitting in the yards. And I know it's used for overflow. So if people come on the weekends and there's extra kids, they go sleep in the RV. I think by having to treat them as permanent is going to cause lots of problems. I think we would be better to look at how to regulate them on temporary basis the way they're presently being used. We don't have enough accommodation in our communities for people to come and get a hotel room to stay for the weekend to go to a wedding. So if you have a $150,000 RV, you truck it along and you pull it out in somebody's yard and you sleep in it and attend the function. I don't know that we want to stop that. So I'm just thinking to have to treat it as if it was a permanent structure being put on the property is causing more hardship to our communities than it is good. And it will be very hard to regulate and to police.
Bill, would you like to add to that?
Basically, my comments were almost similar to what the mayor was making, but I'm wondering, Glenn, if there's any area across the province of Ontario where this issue has come before them and they've come up with some kind of perhaps a permit system when you know that you're having a gathering, as Kathy alluded to earlier. It might be a family reunion or a special occasion of some kind where you're going to have 10 or 15 mobile RVs come in, would the onus be able to put the onus on the landowner who's hosting this to actually get a permit to allow this to happen so that it becomes a short-term thing, not a everlasting one where the RVs are left there for the whole year?
In response to the mayor's comment, the way the bylaw, and maybe I didn't explain it thoroughly, is that that kind of a situation would be permitted. In other words, we make a distinction in the bylaw between the vacant lot situation where somebody's RV would be treated as a conventional dwelling versus a situation where somebody wants to use a lot, use an RV as a temporary accommodation, if you wish, for a weekend, that sort of a situation. And that could be also addressed through through a licensing bylaw, so that you could structure the bylaw to deal with both situations, recognizing that there is a need to address both situations. It appears to me from what was said earlier that you do have those both situations. You have people that want to put something on a vacant lot, but then you have people that want to accommodate relatives for the weekend or something like that. So here's where the multiple bylaw approach is probably required. The licensing bylaw to more effectively, I guess, deal with the weekend and the reunion type situation as opposed to the longer term. So I guess what I'm saying is we can structure the bylaw to deal with both those issues. And that's really what the approach is here.
Thank you, Madam Chair. A couple of questions on that. I had already, first thing I'm going to do is ask the question that with regards to these vehicles on these recreational vehicles. I see some of them on lots. People leave wheels on them, and they're actually a permanent device. Put a fence around the outside, like one of those I don't know what they are. Put a fence around the outside. Say it's a recreational vehicle. I left my wheels on, so therefore it's not a permanent vehicle, and so they're not taxed. I think we've got to put some kind of a regulation in so that if somebody decides to move a RV vehicle on the lot, leaves the wheels on, it's still considered a permanent vehicle on that lot. And I don't think we have anything in the bylaw right now. Some of them have actually sewage systems attached for the recreational vehicle. And the other thing I would think we need to do is to regulate the number of RVs on any particular lot. Yeah. Stone mills ran into a problem, and I think this will be covered under the licensing because I definitely agree with that. Stone mills ran into a problem a couple of years back, and they still have that problem. They do have a licensing thing, but with regards to that, I'm not going to get into a lot of details on it, but it was on the Carroll Road, which some people may remember. And I think we got to regulate that because that's something that we can control through licensing. You just don't want to let somebody come in with a whole group of people that you may not want there for the weekend. So they need to go through licensing. So I do agree with that. The other thing I want to say lastly on the recreational in your right up here, and I did bite you on this with regards to the lot size. I think here in Central Frontenac, you have to take into consideration because we've got a lot of our lots of record. And I mentioned this to you, and I may have to come back to council to agree with this, but we have already official lots of record that are undersized that have been here. So I think we have to take those into consideration too. I know you've limited it here to 1 hectare, which is 2.47 acres, but I think you have to recognize those other ones. But I definitely agree we have to get some regulations around these things because they're getting out of hand. But anyway, that's That's all I want to say in that.
Counselor Dewey.
Thank you. Through you, Madam Chair. I just want to see if I am understanding clearly how you are planning to use. It's almost like a two-tiered system. Part of it is going to be the zoning bylaw, and the zoning bylaw might be quite stringent. But then through a licensing bylaw,
Yeah.
you allow certain exceptions. Is that sort of like the general track that you're on?
That's correct.
Okay, so then we can make the zoning bylaw fairly stringent. We can say we're not allowing the use of these RVs on lots. However, you can apply for an exemption. And then I think also in the zoning bylaw, perhaps there might be a differentiation between a vacant lot where somebody is parking their trailer and living in it, and especially on waterfront, and we'll be discussing this later, using it as a short-term rental. And there's no other building versus somebody who has a primary residence and they've got a trailer in the backyard, which they use on the weekends.
Yeah.
So.
So the question I'm throwing back to you is do we want to deal with both of those circumstances? The mayor is expressing the concern about the recreational vehicle on a vacant lot is not, in her mind, the most important issue. In her mind, what the reality is the weekend user. Okay. But I'm hearing two stories. I'm hearing that, in fact, you do have both circumstances. You have people putting RVs on vacant lots. Okay. And I'm getting the sense that you want to regulate that. But I'm getting the sense you want to allow people to use a recreational vehicle in association with the house that's on a lot, an existing lot. And that could be for visitors or something of that sort. I'm getting that sense as well. Okay. Councillor Dewey, I do have a concern though, if we take that one step further, the situation where somebody is using a recreational vehicle on a lot that's also got a dwelling on it and using that as permanent accommodation, because a recreational vehicle is clearly defined as not being permanent accommodation. It's not defined as a house or a dwelling unit. This bylaw makes a very clear distinction, primarily because a recreational vehicle will not meet the building code requirements for permanent occupancy. It's as straightforward as that. You see, it's not a mobile. That mobile home is different than recreational vehicle. And I have a real concern about situation. Now, it sounds to me like it might be a bit of an anomaly. There might be one in the municipality or two or something like that, but certainly I don't think you want to encourage recreational vehicles to be permanent homes.
No, that's right. That's the only thing that I think some people are doing that. That's something that we need to deal with because they're making it a more permanent residence.
Can't hear you, Tom. Can't hear you.
Sorry about that. Your worship. Yeah, I think we need to deal with that because there are some folks that are doing that, and I don't know how to handle it. They're making that particular trailer a more permanent residence. It's not, there's no house on the property. Now, if that trailer is going to become a permanent property, I have to agree with you, then it should conform to the building code regulations. And that's something that's the
But
gray area.
is it a trailer or an RV?
It's it's probably about a 50-foot trailer. It's got wheels on it. It's transported. It's got wheels on it. An RV, it's the same thing as a recreational vehicle. It's a recreational vehicle or a trailer. So to me, they're the same. If they got wheels on them, you can move them. They're a trailer.
I see Councillor Gowdy has a question.
Thank you. I agree with what Councillor Dewey is saying. We have a large, it's not a one-off. We have a large problem with recreational vehicles, whether it be an RV with a steering wheel or whether it be a camper trailer, that people just plunk them on vacant land. And like you spoke earlier about the drain on the fire services and the drain on the roads department, these people are plunking them there and they're not paying the taxes on them and they're living there year round and they are putting skirts and septic services there. And we do, whether its enforcement is an issue and whether we do license them or put them in the bylaw, it's something that I think we as a council have to deal with. And we have to find to do it because that's what staff's getting the complaints about. And it's throughout the township. It's not one specific area. And whether we do this in the zoning bylaw or in a licensing thing, but we have to have something that we can have our enforcement officers be able to use to either have them evicted. And I think it bears to Mr. Kennedy's reason for being here. They are being rented out for short-term rentals. And like that's, we're opening a can of worms, but we need to fix that can of worms.
Okay.
And thank you, Nikki. I see that Councillor Cameron as well has a question.
You, Madam Chair. I understand and appreciate and largely agree with everything that's been said. My concerns are more about the language, and I think that I'd like some real clarification, RV versus trailer, because technically an RV is not a trailer. Trailers don't drive themselves, so I think we have to be very clear. I think we open up some issues if we're using RV and trailer interchangeably. I think we need to be very precise about that. But to another point, and maybe this is me just looking at the details, a lot of tiny homes have wheels. And so I guess the question is, are we not going to have some sort of definition as to trailer versus a tiny home? Because if someone has a tiny homes, many of them have wheels and can be towed away. If the size of a regular trailer is in keeping within the parameters of tiny homes, I mean, does somebody come to us and argue, well, this is technically a tiny home because, like any other tiny home, it can be pulled away and if it falls within the footprint. I'm not saying that would happen, but I'm just wondering how we would address those issues if somebody wanted to take it up with us.
Okay, in response to your questions, Councillor Cameron, a recreational vehicle and a tiny home are both defined in the bylaw. The existing zoning bylaw has a definition for a recreational vehicle, and that's been in place for 10 years. And I would point out to you that there are examples in the definition. So examples of recreational vehicles include a motorhome, a tent trailer, a camper trailer, a recreational trailer, a fifth wheel, or a bus converted into a motorhome. So it does deal with trailers and other types of recreational vehicles. It doesn't make a distinction. It kind of lumps all of those into the one. And as I say, that's been in your definition in your bylaw for the last decade. Similarly with tiny homes, yes, I've heard the argument a number of times about tiny homes on wheels. The intent of your bylaw as proposed now, with the changes, would be that you couldn't have a tiny home on wheels. The intent would be that the tiny home be constructed and installed on a foundation, and it's likely going to be a slab foundation as opposed to a full foundation or something of that sort. So it's not a question of rolling it in, rolling it out. The intent is that it's a permanent structure that would be accessible for taxation purposes, municipal property taxation purposes. So does that answer your question or questions?
Yeah, I think it does. And I take your point about some of the definitions. And, they have been there for 10 years, but given the fact that we have a new official plan and we are actually talking about tiny homes for the first time and that we're doing this review, I was just wondering, my concern is that that what we're talking about in 2022 is current, and that we're not going to run into situations where there's going to be some confusion of terminology. But I do accept your comments, and you know, it does answer what I'm looking at.
Okay, but I mean, you do raise a point, and it's something I did not indicate earlier, but when I went through the bylaw and made a number of changes, I tried to simplify the language to make it clearer. And I'm certainly amenable to any suggestions on improving the language anywhere in the bylaw that makes it clearer to the administrator and the reader of the bylaw. So your point, Councillor Cameron, is well taken. Okay, so I think I understand then what we want to do with recreational vehicles. It's much along the lines of what is suggested, but I think there's some clarity that's required to address some of the concerns that have been raised this afternoon. But the one final question I guess I have is the way the bylaw is structured is it talks about one RV on a property. And I don't want to complicate the matters, but we've had some municipalities that have said, if you got a larger lot, allow the second RV. You know, it's so you can end up with multiple RVs on a property. You could structure a bylaw to allow that, or you could use the minor variance process to deal with the exception. I think my preference, my suggestion to you would be to use the minor variance process as the way to deal with anomalies to the number of RVs on a property.
One other question that I have, because if we limit like that with one, I mean, myself, I have one, of course, but I don't use it on occasion. It's there for storage until we go out and use it. But someone that has a larger piece of property, then if they want to have a family reunion, then that's where you use the licensing bylaw to allow them then to be a special exception and pay the fee just for that weekend. And I think from what I'm hearing, that seems to be sufficient from council on that part. And I just wanted to clarify that as well. So.
So do I have the understanding then that this council is prepared to look seriously at a licensing bylaw for trailers then?
As well,
Yeah, thank you, Madam Chair. Yeah, so the way I'm sort of seeing it, and I just to be clear, we would use the zoning bylaw to restrict the presence of trailers, especially on vacant lots. And perhaps we can even put it in the zoning bylaw that trailers that are being stored on a lot with a primary residence, that's fine. That's a permitted use. And then we use the licensing bylaw and minor variances to allow for exceptions. So we start off, the zoning bylaw is strict.
Yep.
But we have both the two processes of minor variance and licensing bylaw for the exceptions.
Yep.
And we count.
Yep. Okay.
There still could be some issues in regards to that and allowing minor variances. So that's something we have to think a little bit further through. And just because I know I'm looking at Crystal as to what, and Cindy, as to what's been happening.
My sense is that it will increase the number of applications.
Since,
And they're not,
and it takes time.
Yeah.
By the time you get a minor variance or special
Yeah.
occasion like that.
Use the microphone, please.
yes, no, yeah, Crystal's not up by using the phone, but what she's talking about is, you know, if we allow the minor variances, then by the time it would increase the amount of minor variance applications coming forth, that the committee probably wouldn't have an opportunity to deal with it in a timely fashion. Say, for instance, if they had, you know, a family reunion or any of those things, unless we use, then that occasion would, you know, or allow another minor variant, like another trailer. No, that would be on the license, but an extra trailer, you might have some time that maybe the person for the weekend. Okay. Yeah.
And wouldn't it only be a minor variance if you permanently wanted to put a second? I thought that's what you just clarified.
Yeah,
right?
I would think so, so.
But I assume we get a clear number of that.
They're talking about the amount of applications, Madam Mayor, that they may get.
Yeah,
Councillor
I don't understand why you would need a minor variance if it was for a weekend or 2 weekend. That to me would be the licensing issue. If it was permanent, then a minor variance makes sense.
Councillor McDonald.
Through you, Madam Chair, Glenn, are we trying to reinvent the wheel here? Or is there some generic additions to our bylaw that you can actually bring forward to us to actually deal with this issue? It's not a perceived issue, it is an issue, but how are other municipalities dealing with it? And are we missing the point in some of the discussions here?
As I said, the basic framework that I've suggested here addresses most of what we've talked about, okay, in terms of dealing with the vacant lot situation and then individual lots, okay. What has to be done, I think, is to draw a closer tie between the licensing aspect versus the zoning aspect. And I'm going to have to think about that a bit more. But so as to give you the versatility to do what you want without aggravating or not complying with the zoning bylaw. It's a bit of a challenge because I know you want the flexibility, but at the same time, you've got to be able to say yay or nay. So the minor variance situation probably is not going to deal with the weekend situation. That's not the intent. Albeit, I don't want to throw another dimension in, but you can use the minor variance process under the Planning Act to apply to a licensing bylaw if you want. Most municipalities in Ontario deal with minor variances only with respect to zoning bylaws, but the Planning Act does allow you to grant minor variances to other bylaws. But let's not go there at this point. It just complicates things. But I think I have a sense of what you want to do, and I'll come back, Councillor McDonald, with some revisions to what's been written, and I hopefully being a little clearer. Okay. So that's RVs. Next subject is storage containers. And again, this is a community standard issue. It's a question of whether you want to prohibit them, whether you want to allow them, where you want to allow them, how many will you allow on a lot, and should there be a size restriction or something of that sort. So what's suggested here is to allow one storage container on a residential lot. So not dealing with storage containers in rural lots or non-residential uses like somebody that has a pit or quarry and needs storage container for equipment storage or things of that nature, or a farmer that wants to use a storage container for storing fertilizer or something of that sort. So what's being suggested here is applicable only to a residential situation. Why? Because that's probably where there's greater sensitivity to the potential impact of a storage container on a lot. So think of downtown Charlotte Lake here, and somebody's got a residence, and all of a sudden they bring in a 40-foot storage container. Is that deemed to be an acceptable community standard for your residential area? So again, I'll kind of throw it back to you and say, what is the current situation here in Central Frontenac? Is there pressure to allow storage containers as a regulated use, or is there pressure to say, hey, it's my property, don't bug me? I know if I want to put a storage container on, just let me do it type thing, you see. So I'll throw it back to you then to advise me of what the situation is and where you want to go with it.
Councillor McDonald.
Through you, Madam Chair, to Glenn, I think everything you've laid out here is fair. Okay. The only thing I would add to this would be that a permit would be required to install I don't see that in here laid out anywhere where it says that, you know, you need to get a permit any more than you need a building permit to put up a building that's over 10 square feet.
Stuff. And then Fran, I see you have a question.
So as
Go
of
ahead.
right now, building permit is needed for storage containers. They're treated as an accessory building, and we have a percentage for lot coverage for accessory building. So I don't know that we still want to treat it that way.
Well, the bylaw treats it that way. I mean, a storage container is considered to be a building, so it's, so the lot coverage, okay, is affected. So, I mean, if you have a storage container plus a garage, plus something else, and it exceeds 10%, then it wouldn't be permitted, you see. So it has to meet this, the lot coverage requirements of the bylaw. And as far as the permit is concerned, yes, if it's greater than 10 square meters, then it requires a building permit.
Madam Mayor?
Well, I just think they're totally ugly. They should not be allowed in a built-up area. And if they're allowed in the rural zones, they should have to be at the back of the property, probably camouflaged, because they're so ugly. I don't want to see them in the built-up areas. I think if it were my neighbors that set one on my sideline, I would not like it. And I think we did have one situation with lots of complaints in a built-up area. That's just my opinion.
Well, it's a council decision, and I'm in your hands. I mean, again, it's not a legislative requirement of the Planning Act, but it's a question council has to ask and answer. Do we want to regulate storage containers? And if so, what kind of regulation do you want? So I'm hearing, on the one hand, yes, we should regulate them. And on the other hand, I'm hearing, yeah, maybe fine, but not in a built-up area. You prohibit them in a built-up area. So I'm in your hands.
Councillor Smith?
So what I heard from Crystal though is we are regulating them because they're supposed to obtain a building permit and deal with lot coverage. So perhaps it's more an education thing than it needs, or incorporate what we're already doing in the zoning bylaw, I guess. But also, you know, making sure people know that they're supposed to be getting a building permit if we're doing them.
Well, let me throw the question to Crystal then, because the bylaw right now does not define a storage container, but Central Frontenac seems to be using the accessory building or structure component of the bylaw to allow them. Is that correct?
That's correct. We treat them as an accessory building, the same as you would a garage, a shed. People are using them to live in, but in them cases, they have to have an engineered design.
But to answer the mayor's question, are they being allowed in the built-up area?
I don't know that we've had a lot in the build-up area, mostly the rural area so far.
I'm not getting a clear answer though, yay
Yeah.
or nay. Is there any in?
Well, there probably is, but whether they were permitted and got permits is the next thing, because
Okay.
a lot of them came in with no permits, right?
Okay.
And I mean, there was one definitely on the Brewer Road that we had concerns that people had because of where it was and unsightly, and, you know, I think it was more in the front yard or the side yard than maybe at the back of the lot, and had complaints on that.
Victor?
Through you, Madam Chair. So it seems to me we sort of we're getting stuck in a dilemma here because, no. So I agree with Madam Mayor. The main problem with these is an aesthetic problem. So if we can solve the aesthetics of it, that might be one way to get around it, like require that they be painted. That might be one thing, although they're still boxy and ugly. But we also have the dilemma. We have just previously said that we are going to permit sea cans to be converted into residential use. Well, now are you going to allow them in settlement areas, or is that only on rural properties? And I guess I'm throwing that question out to council. So one, can we solve the aesthetic problem? And two, if we're going to allow sea cans to be converted, are we going to limit where they can be placed? And
Okay.
it's an open question. I don't know the answers.
Well, the answer to the aesthetics is zoning won't do it for you. You cannot require somebody to paint a storage unit to whatever color you want. It's, the section 34 of the Planning Act is not set up to do that sort of thing, you see. So the aesthetic issue is problematic, and I don't know, and I'll admit this, I don't know if any municipality in Ontario has tried to use the Municipal Act to supplement the Planning Act to require something to be done to address the aesthetic issue. I really don't know that, you see.
Councillor Gowdy?
Thank you. I'm looking at the comments, the public comments, and the majority are all in favor of having these containers. So I think that's something we have to think about as a council to take into effect. I agree they're ugly, and I wouldn't want one next door to me. But on the other hand, if the public residents want them, our hands are kind of tied.
And I know North Frontenac allows them, but I'm not sure what restrictions in their bylaw. I know they do.
Councillor McDonald?
To,
And then
to,
Fran?
to Glenn, are we making any difference between residential lots and commercial lots? Because I certainly know that a lot of the commercial operations throughout the county, almost anywhere you go, especially if you happen to be an automotive business, they will use containers to store surplus, or not surplus, but tires, for example, that they don't have room for within their building. I know several car dealerships that have probably 8 or 10 of these storage units out back. So are we differentiating between commercial and residential areas here?
Okay, my comment was we're not regulating anything in a non-residential zone, which means that if you have a commercial zone, then you could put any number of storage containers as long as you meet the lot coverage requirements of the bylaw. Now, that said and I was just kind of anticipating what your municipality might want when I drafted what I drafted. I have made provision for controlling storage containers in commercial areas in other bylaws I've done in Ontario. So you have that authority to regulate wherever and whenever a storage container is permitted. The usual exception in a commercial area is where you're selling them. So you might have a lot, so it's a commercial business to sell storage containers or something, or rent them or something of that sort. So that might be kind of the exception. But other than that, you might be limiting the number of units, number of storage containers to say 3 or 4 or something of that sort, depending on the business.
Madam Mayor?
Would we be able to restrict them in the built-up areas, except if they were going to be used for housing, and allow them under certain conditions in the rural zones?
The answer is yes, in the urban area, and as it stands, or what's proposed here, is that if you allow a storage container, you would have to be in the rear yard and would have to meet the setback requirements of the particular zone it's in. So in the R1 zone, the storage container would be permitted, one storage container would be permitted in the rear yard. It would have to meet the setback from the side yard and from the rear yard. And there is a separation distance between a dwelling and a storage container as well. And I think I've built in 2 meters as the separation distance. So you can deal with it if you want something more stringent than the standard setbacks for an accessory building in a rear yard. You could do that. I'd be open to what your suggestion might be. And your second issue was with respect to the rural area. And as it stands, again, if it's a residential use in the rural area, a storage container would be permitted. Again, provided it meets the setback requirements in the zone and provided it is in the rear yard.
Any further questions from anyone? On the storage containers?
So what is the direction here? Are we going to think about it? We don't have to make a decision now. If council feels uncomfortable about making a decision, that's fine. But I think there's still a varied opinions here, and
One thing I'd like to just question on, you mentioned rear yard. I think we got to look at our lots here in Central Frontenac. What about a corner lot? What about a flag lot? Like, on these lots could be different structured lots.
Yeah.
So I think we need to take that into account too. There's a lot of questions here to be answered.
sorry?
Need to answer before we can make any definitive decision, because lots are structured differently. When you make the comment on the rear of the lot,
Yep.
what is considered the rear of the lot?
Yeah. Okay, on a corner lot, just for in response, is the corner lot setback would be the same setback as the main building. So typically it would be 6 or 7 meters, something of that sort. So it's not something that's going to stick out like a sore thumb, I guess, in the yard adjacent to the street. It would have to be properly set back, just as a garage on a corner lot would have to be set back the 6 or 7 meters on the flanking side. So maybe do you want to think about the storage container issue? Again, I
think we
don't have to
definitely-
make a decision now, but think about it, and we can kind of go from there.
I think definitely we still have a lot to think about with that.
Okay, the next issue is live work units, and this is a concept that was introduced into your official plan. And a live work unit is essentially somebody operating a business full time out of, for argument's sake, a building. It could be a dwelling for that matter, or it could be a commercial style building, but it's got two components to it. It's got the work component, which is the business itself, which is usually ground floor based. And then it's got a living unit, which is usually, it could be a second story, or perhaps it could be the rear of the building on the ground floor. So the proposal here is to establish zones in which those kinds of units would be permitted. So that would be the R1 zone, the RM zone, the commercial zone, commercial recreational zone, commercial local or convenience zone, the business district, the rural district, and the limited services district. So those kinds of, that kind of unit would be essentially permitted in any one of those particular circumstances. And what's been done here is to introduce a definition and to also provide the scope of businesses that would qualify. There's some similarity, as you can appreciate, to home-based businesses, but the difference is really the scale. When you're talking about home-based businesses in this bylaw, you're essentially talking about a maximum of 25% of the floor area, whereas a live work unit it could be double that. So instead of 25%, 50%. But it's really striking the balance between one use as a work use and the other as the living use. What I did, from what you can see in my report, is that I literally excerpted the standards that are set out in North Frontenac and put them in your bylaw because they're North Frontenac bylaw, the home-based businesses provisions, which I drafted a number of years ago, are very similar, almost identical to yours as well. So the live work unit then is the intent behind it is to encourage a form of economic development in your community that allows essentially a small scale business to be located in some of these zones along with the working, the residential component. And the intent is to, in allowing these, is to ensure compatibility between, the predominant residential character of a neighborhood and a building that has a commercial component as well. So I throw it to you to, obviously it's not something you have experience with here because it's not been permitted up until to this particular point. So it's a relatively new concept. And as I say, I've kind of attached it on to the end of the home-based business because it is very, very similar. It's just a matter of scale. We're talking about, instead of basically 25 square feet, 25% of the floor area, we're talking about 50%. But we're also talking about something that's entirely within the dwelling. We're not looking at any sort of exterior storage or anything happening on the grounds outside of the building unit itself.
Councillor McDonald.
Thank you, Madam Chair. Glenn, the rules and the points you've made in the live work thing, I don't disagree with them, but it seems to me that we wouldn't be able to ever enforce any of that anyway. So we don't have the resources in which to find out whether there's more than 5 pupils in a building, or if there's more than 3 people working there or whatever. But explain the rationale to me as to why we would have these rules and regulations around live work units if we're not going to be able to enforce them.
It's a very legitimate question, and so what this council is faced with is whether you want to implement that policy in your official plan, as it's a new policy that says live work units should be permitted. And so if that's the question, if that's what the policy says, does council want to implement that policy? And if so, do you put something in your zoning bylaw? It goes back to the earlier question, though, the whole issue of enforcement is, do you have the resources to administer it? So I kind of throw it back in a sense and ask you, are you having any issues with home-based businesses in Central Frontenac in terms of violations of the existing zoning controls for home-based businesses? And if that's the case, then maybe enforcement is not going to be a significant issue. But it's local knowledge. I don't know what the circumstances here are in the municipality.
I haven't heard of any problems with home-based businesses. Cindy's got a question. She's going to come forth.
So I guess, given the additional opportunity for economic development in these properties, which I think is wonderful, my concern is whether there'll be increasing issues for properties that are serviced by private roads and also by municipal roads, but that are at a very sort of low standard. If people are going to be doing live work units on those types of properties, would we have issues with services and complaints about increased usage, increased commercial usage on private roads, if that would become an issue?
Very legitimate question. And it also extends to some extent about the provision of fire services and emergency services, I should say, emergency services, meaning fire, ambulance, and whatever. Some municipalities take the position of not allowing commercial development on private roads for that reason, because there's no guarantee that somebody on a private road with a business is going to get the emergency service if it's required. I think I'm just thinking of, again, I haven't memorized all the standards and all the bylaws. So in the LSR zone, I'm just trying to think of the uses that we permit in that particular zone right now. And may bear with me for a sec. Okay, so in the limited service rural zone right now, you do have some commercial businesses that are permitted. So you've got a commercial greenhouse, campground, kennel, tourist outfitters establishment. So there are some commercial uses that are currently permitted in that particular zone. Adding the live work unit would probably be less intensive than some of those other uses.
I agree. I just think that there'll be a lot of people wanting to take advantage of this new policy because I think it's good for everybody. So I just didn't know if there's more people trying to start their, albeit small businesses, whether there'd be increased issues and whether how we can deal with those issues.
Okay. So council is faced then, I guess, with the question of whether you want live work units as a permitted use because of the economic benefit or not. I guess that's kind of the question here.
Thank you, Madam Chair. I don't know that that's a question. It's in our official plan.
Yeah.
And so we need to have something reflected in the zoning bylaw because we have it in the official plan. So I think we put it in. It sounds to me as if there's no big concern. So yeah, you're talking the difference is from 25% to 50%.
Yeah, actually I looked at it, it's 55%, but
yeah. And
okay.
I don't think that there's any opposition to that here.
Okay.
I also see Madam Mayor has a question or comment.
First of all, Sonia has her hand up. Maybe we could have her speak first.
I apologize, Sonia. Go ahead.
Not at all. Thank you. Good evening, Madam Mayor, members of council and staff, and Glenn as well. Thank you for allowing me to attend tonight. Just because of the reference with respect to the live work units being new and being within your new official plan. The only thing I want to say is that, so yes, technically you have to implement it, but how you implement it is up to you. I can say as a nearby neighbor example, North Frontenac has permitted them in their hamlets, for instance. So it's not something you have to permit everywhere. And it's supposed to be something that is the next step up from a home-based business, where a home-based business is you're not supposed to be able to tell from the outside of the house that there's a business inside. This is often the next step up. A good example for Central Frontenac might be with respect to Sharpwood Lake and the old school site. So for instance, we've recently had a open house virtually with the engineers who are looking at doing communal services for that site and hearing that we can have a much higher number of residential units. We still have some planning work to do, and we've certainly heard from the community that there's a desire to see mixed use potentially on that site. So an example would be is if there were going to be 1 or 2 small 3-story apartment units, some of those ground floor units could be constructed in such a way as that they could be residential or they could be for business uses. Now, it wouldn't be any and all businesses, but it could be things such as a hairdresser or an accounting business, something like that. And it could be converted either way. And there could be something on the ground floor, somebody on a main street where somebody also owns the unit above and lives in the unit above. So there are ways of implementing it, but it is intended to be something that is more geared towards settlement areas, I would think, that as opposed to just allowing it everywhere in the municipality. So I just wanted to add that for some clarification and to let you know how one of your neighbors is currently using or implementing that policy. Thank you.
Thank you, Sonia. Madam Mayor, sorry.
Okay, thank you. I think it's a great policy, and I think it will be utilized. I can see with the cost of building things right now, if you are going to have somewhat of a business, it just makes sense to put living quarters over top of it or beside it. Maybe one of the things we should take a look at is not allowing them on private roads unless they come for an exemption. To deal with the situation where Cindy is saying, the road wouldn't be up to standard, and part of a zoning change could be that the road be brought up to suitable standard for the traffic. So that might be a possibility to deal with that type of situation. But overall, I think it's a great concept.
The issue with respect to the official plan is I don't think that restricting them to the hamlet areas or settlement areas alone is necessarily fair, given that you are a rural community and the predominant area of your land base is rural, and it's not uncommon even in our area. I live in Drummond, North Elmsley. It's not uncommon to see people living and working and so forth at home in rural areas as not restricted to settlement areas. So I do think it should be broader in scope, and because if you're allowing home-based businesses in rural areas, why would you not allow live work units in rural areas as well? It may be subject to some more stringent controls when it comes to private roads, as the mayor has suggested. Does that sound make sense?
So I think everyone agrees. And I just wanted to check with everyone and see how everyone's feeling, because we have had a lot of discussion and taken in a lot of information. Is everyone feeling like they'd like to persevere and push through this, or do you think you would like to end at some point, pick an end point, and then have time to think about it and come back at another time?
Yeah, I do have another meeting tonight, believe it or not. So I anticipated probably going to maybe I could probably 6:30, I guess, but I beyond that, I think I'm constrained. But I know it's been a lot of discussion and so forth, but a lot of excellent feedback and questions and so forth.
Would you want to? Because that's a big issue. I'm thinking short-term rentals is probably going to have a lot of discussion, and Terry's here for that. So I guess if we wanted to go through the short-term rental, and then that might be a good stopping point.
Yep.
With everyone. Okay.
Yeah.
Okay. Thank you.
Yeah. I think the most I've done in this bylaw, this is at the present time, and I think you see it at the bottom of page 4, is provide a definition. I haven't put any provisions in the bylaw, albeit I have drafted potential revisions that could be put into the bylaw. But this is an issue here again, where enforcement is the crucial component. And I think this council has to ask itself the question as to whether you're prepared to enforce the short-term rentals. I mean, you've got a lot of people that are that are renting their cottage or something to good friends for a week or 2 weeks or something of that sort, and nobody knows about it. It happens. There's no issues and so forth. And I don't know how many situations I know on Bob's Lake, because I have relatives on Bob's Lake that they do that, and nobody else would really even know about it or whatever. So you get a lot of circumstances where it's probably not an issue. There's no issue of noisy parties and beer bottles thrown all over the place and damage to properties and that sort of thing, you see. But to get at the core of this issue is a question of whether you have a licensing bylaw to go with it, or whether you simply let the OPP deal with obnoxious circumstances, people doing whatever they do, or trespassing or doing things that are offensive. But here, if you're going to deal with the issue, you're going to have to deal with the fire safety issue. You're going to have to deal with the noise issue. You might have to deal with animal issues as well. People bringing pets or whatever that are just let run free or something of that sort. You may have health unit issues as well. So it's a complex issue, and the work I've done is to look at what's been done in Lake of Bays, which was one of my other municipalities, and they've probably done the most thorough analysis of the situation of any municipality that I can see. And there's certainly been others, but admittedly, they have said as well is that you can't just simply depend on zoning. Zoning's not going to do it for you. Zoning could say, yeah, it's permitted, but really a zoning bylaw deals with land use. It doesn't deal with occupancy. It doesn't deal with people's doing what they do inside. So there's that sort of a distinction, you see. I guess what this council has to decide is whether they want to go the whole 9 yards, so to speak, and put a licensing bylaw in, and then be prepared to license, and therefore obviously have to collect fees from people. And when do you do it? How do you do it? Who does it? That type of thing, which is probably what you would have to do to enforce it properly, or whether you ignore the issue and as I say, let the OPP deal with it if there's some sort of a transgression of criminal nature or whatever, or whether you deal with it selectively. I mean, you could deal with the noise issue if you have a noise bylaw and somebody that can enforce that. So, but I guess do people understand what short-term rentals are? And I gather you do. And what I don't know, and talking with Terry is and Terry and his group were saying this, is they really don't know, how many short-term rentals we have. Where there's no database to say this is an issue that's widespread, or whether it's just the odd situation where people are just not respecting the rights of their neighbors and so forth.
And I think, Glenn, you're right. I mean, there are I know of at least 2 homes here,
yeah,
and they're right here in the village,
yeah,
just outside, and they're renting them as Airbnbs.
Yeah.
So, I mean, some people may know that, some don't. I don't know if there's been many parties per se that there's been an issue. So we do know it's happening, and it's just to be able, and you're right, we don't know how many that's going on, and that's a big issue to try to figure that out too.
Yes, and I see our chief would like to add to that, and as well, I see the mayor would have questions or comments after that. Would you like to go first, Madam Mayor?
No, let's have Chris, and then Brent had his hand up as well.
Oh, I'm sorry, Brent. I didn't see your hand. Go ahead,
Thank you,
Chris.
Madam Chair.
Can't see the hands up.
Okay. So if we are going to pursue this through licensing, this would trigger inspections for fire. I would recommend not. It's no different than a rooming house. If I can put it to that, not in the sense of how it's set up, but in rooming house licensing, in my past experience, it would trigger an annual inspection every year for the licensing. It would certainly take a lot of pressure off the owners of the building to know that they're getting an annual inspection as well. So if something did happen, that would be confirmed that they have the proper life safety systems in the building and that they're being maintained. Just my comments to that. Thanks.
Thank you for that, Chris. Okay, go ahead, Madam Mayor. And then we have Councillor Cameron, and then we'll do Tom.
Okay, I would just like to start by saying that my guess is we have hundreds of short-term rentals in our municipality. There have been a number of complaints. I've fielded a few of them. I've been working with North Frontenac to try to put together a bylaw to deal with it. And we've got lots of good short-term rentals, but the handful that are bad are the ones that make everybody's lives miserable who live beside them. And those are the ones, unfortunately, that we have to go through, or I think we need to go through a licensing bylaw at some point. It's going to be a horrendous job, and I don't think we are able to really deal with it in the zoning bylaw, but I think at some point we need to definitely do a licensing bylaw and start to deal with the bad ones. That's it for me.
Thank you. Councillor Cameron?
Thank you, Madam Chair. I would agree. I think that a permit system or a licensing system is the way to go. I hope that we don't create undue hardship for very responsible parties. There are some family-owned cottages where, and I can think of some in my district where they've been renting out units for years, and it's very much a family business, and they're right on top of it, and they have regulars that come and visit, and they're very mindful of the behavior of those people that they rent to, and it's a very predictable thing. But then you get these situations where people will do an Airbnb and you have absolutely no idea. I think that the value of the permitting is not in how much money it brings in. I think it's just knowing who are the people and not having the situation where all of a sudden a bunch of strangers show up at a particular property and all heck breaks loose, and people have absolutely no clue how they got there, why they're there, what's going on, and if there is a problem, being able to reach out. And we talk about the OPP, but half the time, their thing is, well, we can't contact the owner. So I mean, having some sort of permit or licensing structure where at least we know who's there. So if there is an issue, but my concern is not to make it financially onerous. And again, I can think of one family in my district that has been renting family cottages out for a while, and they're not making money hand over fist. They're just typical mom and pop operation. And I wouldn't want to see something that's too onerous for them. I would want to see something that addresses the bad behavior, gives us a course of action and some paper trail where we can help the OPP. And as well, we can follow up with the owners and say, you need to pay attention to who you're renting it out to, and not just pawn it off to some third-party operator who is just, processing payments, not really doing a oversight.
Thank you, Brent. Councillor Dewey, and then Councillor McDonald.
Thank you very, very much, Madam Chair. I agree with the chief. Knowing about these people and doing inspections is important. Problem I see in the whole process is that a lot of these people you're not going to know about. They're not going to come in and get a license, so therefore you're not going to know about them. Now, the only way we can know about them, because they do a lot of advertising on social media. They have their own little web page, and they also can advertised through Facebook and things like that. So we'd have to have somebody monitoring that all the time. And then we would have to approach them if they're legitimately in that business. But it's the ones that we're not going to know about and they're doing it all the time. And that's the ones that I worry about. And we've got lots of them in our area. So.
There's one other issue that was brought to my attention on this matter, and that's the whole issue of insurance. Is that if you have a residence, you own that residence and you're renting it out to somebody, what does your insurance company say about what happens if there's damage or something of that sort? I don't know the answer. I think that's an issue for a solicitor or whatever to to address. But I would think that if you're moving towards any sort of licensing, you're going to want to answer that question as part of it. So it's not a zoning issue, obviously, but if a residence is destroyed or damaged, seriously damaged, and what does the insurance company say? They may not be prepared to provide any compensation to you if it's damaged. So I think the insurance issue is one of the factors that you have to deal with. So I think what I'm getting the sense here is that you want to deal with the issue, but probably not through the zoning bylaw, that you deal with it. As I say, a zoning bylaw is land use, what you can use a building for, not who uses the building, you see. So, and it's not going to be resolved tonight, obviously. I think what the suggestion is it's going to take time to deal with it. And the mayor is correct, is that there has been a committee sort of struck amongst the 3 municipalities. I think South Frontenac's involved as well, kind of looking at this particular issue. So maybe a case of working that through. And it's not to say that you can't amend your zoning bylaw at any point in the future as well, because often, in my experience, notwithstanding the hard work that goes into updating the zoning bylaw, sometimes there's a need for a housekeeping amendment a year later because, we did something that didn't quite work or whatever. We did that in this bylaw as a matter of fact, sort of thing, you see. So is it fair to say we put this kind of on the back burner at this point from a zoning standpoint?
I think Councillor McDonald's just bubbling over with a question here. We'll take that and then.
That's all right. I probably already said enough, but Glenn, you covered some of the points I was going to make, and I think it's a liability issue for the homeowner by doing this without a license or without any agreements anywhere. If someone is renting out their cottage, and I assume that all the assets that are that cottage, like boats and ATVs or whatever else, if someone got hurt while they were doing that, where does the liabilities sit? And so I think there has to be an understanding of liability. But in the final analysis, we're not doing this alone, because this is an issue right across the province of Ontario. So whatever bylaw or licensing agreement that we come up with, I think it has to conform with all of the other districts so that we don't get a flow of people renting, saying, well, I can go to South Frontenac and rent a spot there, or I can go to the Muskokas and rent there. So what we need is something that's going to be conformed to right across the province, whatever that takes, because it's an issue everywhere. It's not just here. But all the other points, Madam Chair, have been covered by other speakers. Thank you.
Okay. Okay, so it's 10 after 6 now. I guess my question is, do we want to set a date for another session? And we got a couple of issues here we want to deal with going to the public at some particular point, but I certainly don't want to encourage council to go to the public unless you're comfortable with what you have in front of you. So should we try and set a date for another meeting?
Yes.
What's your pleasure?
What do you think, Kathy? You probably have a better idea. Well, yes, I apologize.
Sorry?
What's your availability?
Well, I think the sooner the better. This is the 18th. I could suggest the 24th or the 25th. So that's okay. So 20.
I believe Councillor Cameron and I have an arena board meeting on the 25th, and I'm not sure about anyone else's again.
So what you're saying, you're talking about June then?
You want early June then? There's what, the first week of June is the 6th, doesn't it? Isn't that the week of?
June starts on the Wednesday. June 1st is the Wednesday.
Yeah.
How about June 2nd?
When's that? What date? That's
So
what
Wednesday.
Madam Mayor was suggesting.
Thursday.
2nd?
Oh, sorry, Thursday, yeah.
Does June 2nd work for everyone? Okay, let's go
Okay.
ahead and say.
So June 2nd at 4 o'clock?
Yes. Pardon me?
Yeah, June 2nd, he said 4.
Yes. At 4 o'clock.
Looks like it's available. Okay. I think Madam Mayor's going to get her calendar. How's June the 2nd
Yes, that works.
at 4 o'clock? June 2nd
Yep.
here. Okay. I think we've got a date.
Now, can I, if we're good on that, I do also want to ask the question about your, or get some feeling for your thoughts on the public consultation component. I had said, you could have one meeting here as your public meeting. You could have 2 or 3 meetings, maybe one in Arden, one in South Mountain. Sorry?
I don't think that we can go to other places because of the technical setup and also allowing for Zoom attendance.
There's just not the capability of the
Yeah.
internet and things right there. So
Okay.
we would have to have it here.
Okay. Now so one meeting is going to suffice, you think, or?
No, not likely, because I mean, there's going to be a lot of public
Yeah.
and summer, people now back for the summer. Are we going to do something like an open house? Like we've done before. We've
Yeah.
done a Saturday morning, like from 10 till noon or so. Is that something that works? I know it has in past. Yeah, and it worked.
We had a public meeting on a Saturday morning when the visitors, the seasonal residents were around.
Yeah. And basically it's your open houses and then you come back.
I think that would be advisable. There are going to be a lot of people that would like to weigh in on this, and we should give them the opportunity.
Yeah.
Would we have our mapping done by early, say, June or early July or August? Because people tend to like to look at those maps and find their own properties and look at the zone, and that's where we pick up on things.
Yeah, that's the other question that's really outstanding is the mapping, is that I have to deal with whoever's doing your mapping, I guess, and we should start to update the mapping as soon as possible to
Update the
build in
mapping.
all those amendments that
What's
have been
that?
made.
Oh,
But yes, you would definitely want the mapping available for any public consultation.
also
For
too,
sure.
I think Cindy just mentioned June the 2nd. June the 2nd is the election,
Oh, that's right. too.
provincial election.
That's why it's open.
Back to the drawing board, I guess. Any other
not gonna
suggestions,
work.
Glenn?
No, that's not going to
How about-
work. So we'd have to go
about
that
June
week
the
of the
6th?
6th. Yeah, the week of the 6th.
June the 6th.
How
work-
about that Monday,
Glenn?
the 6th?
Monday's the
Yeah.
6th.
That works for Glenn?
Yeah.
Cindy's just checking the hall availability. Oh, well, so we should be
we
done.
should be
We're
done by
starting
that
at
point.
4. June 6th,
June
a Monday.
As well, Councillor Heath was just giving a reminder that we need to clarify whether it would be a public meeting or an open house, as they are different.
Oh, yes, when we do
processes.
for the summer. Yeah, once council gets through this, and like the Madam Mayor was asking about in regards to the mapping. People like look at maps to see what I think an open house seemed to work before, because that gave the people the opportunity to look around, look at the maps and speak with yourself, Glenn, or anyone else. And then after that, you do your actual public meeting section.
Well, it may be possible then to have, to look at it this way, is to have two public meetings, both of which would have an open house component before the formal meeting.
Yeah, we could do that, yes, correct.
And it sounds like you would have one of those on a Saturday morning here. And the other would be here as well, but it probably would be a late afternoon or evening meeting or something of that sort. Does that? Okay, so we're saying basically two meetings should suffice.
Should suffice.
And depending on the response, it's always possible to have a third. I mean, it's totally the discretion of council on the number of meetings. The Planning Act says you have to have a minimum of one, but you know, you can have whatever number you want. So.
Well, and we have to remember it is an election year, so whatever meetings we're doing, we should probably get out of the way early summer.
Yeah, it's the timing is a bit tight because we have to give 20 days notice for the public meeting. So we will have to maybe think about it between now and the 4th of June. Council can think about some possible dates, or 6th, I mean, sorry, the 6th of June. Think about some possible dates for Saturday morning session and yes, an evening session. I mean, they could be almost side by each. You could have a session on the Saturday and then on the Monday have the second meeting or something of that sort. Yeah.
Well, thank you very much, Glenn, for your time this evening and all of the information. And before I read the motion, do we have any further questions or comments from anyone? Okay, I have a motion moved by Tom Dewey and seconded by Victor Hees that council received the planning report prepared by Glenn Township for information. All those in favor? Motion is carried. I have a motion moved by Victor Hees and seconded by Nikki Gowdy that council receive public feedback generated from our Engage Frontenac project page for information. All those in favor? Motion is carried. And I have a motion moved by Bill McDonald and seconded by Tom Dewey. Sorry, Tom. That the bylaw 2022-31 being a bylaw to confirm the proceedings of the meeting held on May 18th, 2022 be read a first, second, and a third time and finally passed this 18th day of May 2022, and that further this meeting be adjourned until Tuesday, May 24th, 2022, said meeting being held in person at Soldiers Memorial Hall, 1107 Garrett Street, Charlotte Lake. All those in favor? Motion is carried.
You did a great job.
Have a great evening, everybody.
Have a good one, everyone.
Good job, Deputy Mayor.